Hello everyone, this is Narendra from Civil Department. I am going to explain about construction disputes which is comes under project management 5th unit. Construction disputes arises from the environmental and behavior factors. There are many different causes of the disputes in the construction industry. Disputes waste of the money, therefore drain profit and destroy the relationship, and it takes energy away from the projects. The construction delays, variations, efficiency issues, and exceeding cost can be some causes for the dispute arises in the project. Typically, construction disputes occur between the owner and main contractor or subcontractor or subcontractors and design professionals. The main definition of the dispute is nothing but a misunderstanding between the two parties, either contractual or non contractual. Dispute is unable to eliminate because the nature of the construction is full risk. So, definition of the dispute may be circumferenced, it may inevitability involve resolution of other matters which may not specify have been raised into the separate or discrete dispute. The main factors affecting construction disputes are the terms of the contract, what are the terms included in the contract document, and what type of technological issues, and project conditions also may be a type of factor which will be affect construction dispute. The parties involved in the construction process and magnitude of the construction project and site conditions also may be arises or may be affecting the construction dispute, and degree of bias and third party and also organizational behavior. The last one is cultural. So the human culture also will be affected for the raising of the disputes in the construction industry. The number of causes of the disputes are failure to properly administration the contract, and poorly drafted or incomplete or unsubstantiated claims, and employer, contractor or subcontractor failing to understand and comply with its contractual obligations. And also the deficient management supervision also will be a type of cause, and the lowest price mentality in engagement of the contractor, that is also a type of cause which will be rises for the dispute by the client. And poor communication between the parties, and discrepancies in contract document, and failure to appoint project manager, and failure to respond in time, and failure delay in the suspension of the work, that is also a type of cause which will be raises the dispute, and lack of understanding and agreement in contract procurement, and inadequate CPM scheduling also will be raises a type of dispute in the construction industry, and different failures to plan the and execution of the changes of the works. Some kind of the works will be changes during the construction process, that will be also raises a contractor disputes, and failure to understand and correctly bid or price the work. So these are the number of causes may be affected for the raising of the dispute in the construction process. Now we go for the what are the benefits of the expert determination. So here the meaning of the expert determination is so it is oftenly used to resolve issues or disputes of a specialist nature such as construction, and is one of the most informal systems of dispute resolution, and it is often used when there is a valuation dispute. If an expert is to be used to determine the dispute, the parties will be agree this by. So, if an expert is to be used to determine the dispute, the parties will agree this by contract will, and will agree that the expert determination will be binding. What are the benefits of the expert determination? It is an economic way of finally resolving valuation, disputes, it is less expensive and a quicker and less formal method of a dispute resolution process. So, some kind of disadvantage also expert determination. The use of the expert is much less tied to legal processes, and therefore it is more difficult to challenge the decision of an expert. An expert's report cannot generally to be enforced without further court or arbitration proceedings. So, second one is the litigation process, which is also useful for the resolution of the dispute. While there are many methods of the ADR, court proceedings are still one of the most common forms of resolving disputes within the construction industry. The Technology and Construction Court is a specialist court which deals with the technology and construction disputes and is governed not only by the civil procedures rules but also by the technology and construction code guides. A specialist TCC judge will deal with the case in the TCC processing. That means technology and construction code. The different advantages also there for the litigation. The claim process will be managed by a judge throughout it will be resolution process. Complex issues can be dealt with. The parties will obtain a binding and enforceable decision process. Disadvantage of the litigation process: only the claims which are over the value of 2,50,000 can be dealt with at TCC process. Any claims below this sum of the dealt, the court cannot be go for the resolution process. It is often a slow process and it will be most expensive also. Those are the disadvantages. Coming to the mediation, that is also type of process for the resolution of the disputes. Most commonly used process, this one is in the construction industry to resolve the disputes among the different parties. The Technology and Construction Code guide provides guidance on the conduct of litigation within the construction industry and states that the court schedule encourage parties to use alternative dispute resolution process ADR, which in most cases will be a mediation process will be useful. And different benefits of the mediation process are: the mediator will be an independent person who will not make a decision, judge or advise, but will be facilitate discussions between the parties with the aim of resolving the dispute. The mediators are generally highly experienced in the area of the dispute and may even by TCC judges also. It can help maintain a business relationships. It is relatively quick, with mediation usually lasts 1 to 2 days. The resolution process will be completed within 1 to 2 days of the time. And different benefits also: continuation. It is usually considerably less costly than litigation process. Everything that happens in a mediation is confidentially, because no more third person will be involved in the mediation process. Only the two parties and mediator will be involved in the mediation process for the resolution of the dispute. And disadvantages: some cases there may be a concern that during the mediation parties may disclose an important aspect of their arrangement, argument, or commercial position, which confidentially could benefit the other party if the matter went to trial. If the parties do not come to an agreement, the dispute will remain unresolvable and cost of mediation will have been wasted. Then, the most commonly used method for the resolution of the dispute is arbitration process. It is another alternative to litigation and is a process in which the parties will agree to refer the dispute to a third party, the arbitrator. Disputes are resolved on the basis of material facts, documents, and relevant principles of law. Arbitration is often used in the context of international construction disputes but can equally be used for pure domestic disputes. The main benefits of the arbitration, like mediation, arbitration is a confidential process. Parties can agree and an arbitrator who has relevant experience in the matter. Compared to court proceedings, it is a relatively quick process because there is no more time will be taken for the resolution, like mediation process or litigation process. The arbitration process, it will be take a lesser time for the resolution of the disputes. All kinds of the disputes may be resolved by the arbitration process is very easy. It is highly flexible compared to court proceedings. The main disadvantage of this arbitration process is it is the party's responsibility to bear the cost of the both arbitrator and venue cost, and also arbitration is to take place. Wherever we go for the arbitration process, the main disadvantage is the bearing of the cost of the both arbitrator as well as venue cost is only the party's responsibility. There are limited powers of compulsion or sanction available to the arbitrator. If one party fails to comply with the decision set by arbitrator, there are limited appeal rights available during arbitration, and cost can be similar to litigation at court. These are the main disadvantages of the arbitration process. So mainly we discuss about this dispute resolution process is so firstly we discussed about what is the meaning of dispute and what is the definition of the disputes. So construction disputes, what is the meaning or what is the introduction part, and then we go for the discussing about the definition of the dispute. Dispute is that misunderstanding between the two parties either by the contractual or non-contractual. So the main definition of the dispute may be circumscribed. It may be inevitably involve resolution of other matters which may not specifically have been raised into separate or discrete disputes. Then we seen about the different factors. What are the factors will be affected for the construction disputes? Maybe the factor terms of the contract may be affected. What type of terms involved in the construction contract document or agreement? Those will be also affected for the raising of the disputes among the parties. And technological issues also may be arises, like technical people may be arises some disputes among them. And project conditions, what type of project conditions may be arises the construction disputes, and different parties involved in the original parties or different parties involved in the construction process, there may be also arises some kind of disputes between the parties, main parties. And magnitude of the project will be also affected by the raising of the disputes, and different site conditions also may be arises, a degree of bias. So here the third party member also may be included in the original parties. Those will be also arises different kind of the disputes among them. And organizational behavior and culture of the people will be also arises some kind of disputes. These are the factors we have discussed. And different common causes also discussed, like deficient management supervision and poor communication and failure to appoint project manager and failure to respond in time while the disputes are arising. So these are the number of causes we have discussed. And also what type of methods we go for the resolution of any kind of disputes in the construction industry between the parties. So we have discussed about adjudication and about expert determination, and also we discussed about litigation process, and also we discussed about arbitration mediation process. So mediation process means a mediator, it will be resolved between the two parties, and also we have discussed about arbitration process also. So arbitration process is the main process and frequently used process for the resolution of the disputes among the parties. These are the things we have discussed in this class. If you have any doubts, you can ask in the chat box, and please subscribe my channel and follow the channel. Any kind of doubts you can ask in the classroom itself or else comment box. Thank you very much. Thank you for your understanding. Thank you for your listening also.